Hello everybody. For the first time ever, I'm cross-posting between my YouTube and my Facebook video. In the next probably couple of days, I'm going to go to Verizon and get a new screen protector. The video is really bad on it. So for anybody watching on Facebook, apologies to that. My face is much better on YouTube, and you guys should check out my YouTube channel, Phil's Bills. I will put a link at the bottom of this video on Facebook. So anyway, I wanted to talk about PG&E, bad decisions, and what causes California to bail out PG&E. So let me just kind of give you the quick lay of the land for a minute. For all those who don't know, for people who maybe are watching this outside the state of California, PG&E is a very large utility. They operate largely in Northern California, San Francisco Bay Area. They operate in Stockton. They operate in Sacramento. Somewhat, I know Sacramento has the Sacramento Municipal Utilities District, otherwise known as SMUD. And I know Modesto also has, I think it's the Modesto Irrigation District, MID. But anyway, PG&E is essentially a utility company of a swath, of large majority of people in Northern California. They are a behemoth company. They are regulated as a public utility, which means, they're a privately owned company, but the state has their hooks in pretty much anything and everything that PG&E does. So, for example, if PG&E wants to raise prices, they have to apply with the Public Utilities Commission, and they also have to apply, with the Public Utilities Commission for a wage increase, for a rate increase. And the Public Utilities Commission can say no, they can say yes, or they can tell PG&E, okay, you can raise rates, but at this level, right? And the idea was that the Public Utilities Commission would protect the consumer from unnecessary price gouges. I think a lot of people had a problem with that about 2 years ago, when suddenly people's gas bills started shooting up in the dead of winter by like $50 to $100. Well, that was because PG&E went to the Public Utilities Commission and said, hey, we want a rate increase. And the PUC said, yeah, absolutely. Of course we'll give you a rate increase. We think it's absolutely necessary, considering the fact that you need more money in order to maintain your network. So PG&E, they're a large company. They're probably one of the least popular companies in all of California. They're one of the least popular utilities in all of California. And quite frankly, nobody likes them, right? There's no love lost. However, and there's a reason that they're a public utility, and that's because people need them. Obviously, people need gas, they need electricity. There's no debate about that. So the question is how best to make sure that we get what we need without getting gouged for it. So we need to go back to the Wayback Machine. We need to go back to the year 1997. And in 1997, the California Supreme Court had a case regarding, I think it was the Edison Electric Company out in Southern California. I think it was called Southern California Edison. And Southern California Edison, like PG&E, was a public utility. And Southern California Edison, like PG&E, also had a lot of fires happen on properties associated with where they were putting up their wires, they're putting up their electricity, so on and so forth. And so Southern California Edison basically said, hey guys, it's cool if you want to sue us, that's great. Of course, we're a company, we can't really fight you wanting to sue us. We just ask that if you sue us, you apply what's called a negligence standard. And a negligence standard basically says that you have to prove that the company acted unreasonably in maintaining its property. In other words, if a downed line caused a fire, was the line downed by excessive weather conditions, or was it downed by a failure to adequately, latch the line onto the pole, right? If it's the latter, under a negligence standard, Southern California Edison's liable. If it's the former, Southern California Edison would have survived. Complicating their matters is a little thing called inverse condemnation, which is related to another little thing called eminent domain. What's eminent domain? Eminent domain, for pretty much anybody who loves property knows what eminent domain is. Basically, eminent domain is the idea that the state can take your property and apply it for personal use, or for another's benefit, as long as that other's benefit can better benefit the public. So, for example, if I was operating a house, if anybody's seen the Disney movie Up, I think you might know where I'm going with this. If I'm operating a house, and that house is surrounded by a mall, and that mall is generating all tons and tons and tons of revenue, then I, as that house, I'm going to have a problem. Because let's say that mall wants to expand, and my little house is in the middle of that mall. And the mall says, hey, look, we'd like to buy you out. But this is my home, I say. But this is a place I live, I say. So I refuse. So what can the mall do? Well, the mall can go to the state and say, hey, state, help us out. This mall is clearly profitable. The tax base, the tax revenue that are going to our workers, that are going to the city, the county, is far more voluminous than the property tax revenue from this little rinky-dink hut. So, what do you do? Well, the state says, okay, we're gonna take over the hut. We're gonna take over the house. It's gone. Now, under the law, they have to pay fair market value for it, right? And the state can get tied up in court on what fair market value is. But basically, once that's determined, the state can buy them out, and they gotta go, right? And so the mall can expand. For all of us who don't have balloons and can't float out of our situation, there are certain other remedies. There's something called inverse condemnation. So, say the state takes your property, right? But then after they hold on to your property, they don't give you fair market value. Or let's say, let's kind of tweak the example a little bit. Let's say the state only takes part of your house. Not all your house, but part of your house. Let's say the state takes half of your house. They can do that too. Because they need it for, I don't know, a phone line. I don't know where this is going, guys. Let's say the state needs to take your house for a phone line, or part of your house, or part of your yard, right? And they put the little phone line up there, okay? And that phone line burns. And in the process of it burning, it burns down your house. And it burns down the houses after that, and so on and so on and so forth. Well, that fire started at your property. Or that fire started at the government's property that they took from you. What would happen in that situation? Something called inverse condemnation. Inverse condemnation is called inverse because in this situation, the condemner, in this instance the government, is actually the one causing the property to lose value. I'm sure most people here have heard of what condemnation of property is. When you get your property condemned, what happens is somebody comes in, they take it because they say you have caused this property to go to waste, thus losing value, and the government takes it with the idea that the government's going to make it better. In this situation, an inverse condemnation action in court, in law, is what happens when the government takes a property and makes it worse. So in an instance where the government causes your property to burn down to the ground, you can sue under an inverse condemnation statute. That's what happened in 1997. They sued. But Southern California had a sense of, wait a minute, guys, before you sue us for inverse condemnation, maybe you should prove that we have to be a public entity first. Right? We're not the government. We didn't take it from you. We didn't even work with those guys. We didn't even talk with those guys. We're just like, great, thanks for the property. We moved on. Well, the California Supreme Court said, well, hold on. No. You're the beneficiary of this action, and we don't think that the fact that you're a private company means jack diddly squat. So, once you took over this condemned land, this land seized by eminent domain, right, you became the government for all intents and purposes. And anything that happens on your property makes you liable. And this is the rub, ladies and gentlemen, of all of this. See, so I was talking about negligence earlier. The reason why inverse condemnation is so important is that inverse condemnation gets rid of the negligence standard and replaces it with basically what's called a strict liability standard. Strict liability is the idea that you're liable for something if it happens on your property, regardless of how reasonable you were in preventing it from becoming a catastrophe. So you could have done something super spectacular, super awesome. You could have buttressed and triple buttressed and set the 101st Airborne to make sure that light pole wouldn't catch a flame. But if it catches a flame under inverse condemnation, you are still liable. That's it. You're still liable. Game over. So as you might imagine, Southern California Edison had a very strong incentive in fighting that. But they lost. And obviously, while PG&E is in Southern California Edison, they are as close as you can get. They're a private company that gets land from the state government for the purposes of building their own power lines on. So what affects Southern California Edison also affects PG&E. And so PG&E, ever since 1997, basically knew that any property damage that happened on that any fire damage, anything that was caused by their property, made them strictly liable. And that didn't just include fires, by the way. That didn't even just include forest fires, right? I think about somewhere between 3 to 5 years ago, in San Bruno, a PG&E pipeline exploded, caused $1 billion in damage. Guess who was liable for that? PG&E. They didn't have to prove negligence. All they have to prove was where the fire started from. Right? The only way to get out of something like inverse condemnation is to prove that somebody else started the fire. Well, they couldn't, because that wasn't the case. And so PG&E was out for $1 billion. Nothing PG&E could do to fight it. The law is clear. No point in going to court. No point in wasting attorney's fees on that. So PG&E had a problem, right? But PG&E, I mean, they couldn't do anything about it, right? PG&E needed to be itself, right? Like, they have to provide power. You can't provide power without building power lines. So PG&E was kind of screwed. They were in this catch-22 situation. Well, along comes the campfire, right? And before the campfire comes every fire that can possibly be imagined. The fire up in Napa, I forget the name of that. The Butte fire up in Calaveras in 2015, right? Because of the belief of climate change's ascendancy, and that climate change was creating stronger fire conditions, right? And I'm not going to get into that discussion right now. But because of that belief, and because of the fact that, look, there were stronger fires, right? And very regrettable. PG&E was going to be out billions and billions of dollars. California had no choice but to step in. Look, I have no love for PG&E. It's PG&E, for goodness sakes. Right? This is not Coca-Cola we're talking about. This is not like a beloved company, even though that we can forgive their largesse because they provide us with warm family memories around Christmas. Right? I mean, yes, PG&E does provide warmth, but that's about all they do. Nobody likes them. Right? Nobody wants to see PG&E thrive. Right? They get the help of the federal government to run their operations. That's, they don't really beat the market competition. The problem, of course, is what happens to all of us. Right? PG&E is a company. Remember what I said earlier. They can charge rates. They can ask the Public Utilities Commission for an increase in rates. What do you think would happen if PG&E had to spend out billions and billions and billions of dollars? Well, they declare bankruptcy. And what can they do in bankruptcy? Well, they can, A, not pay off their debts, which means fire victims are screwed. They can, B, not pay off, or they can charge more people for money, right, in order to pay off the certain debts that they can. So the way bankruptcy works is once you declare it, you get to reorganize and you get to prioritize the debts that you pay, right? So somebody would eventually get screwed. Maybe fires, maybe people damaged by the fires, although admittingly their insurance company would probably step in. Certainly insurance companies would feel the brunt of it, right? As any payments to them would be held up in bankruptcy proceedings. Right, even if they ended up winning, even if as an outside debtor or an outside creditor they were entitled to money, they would still lose. PG&E shareholders, they would lose. And before you say, well, poor shareholders, woe is them, we really feel sorry for them, keep in mind, a lot of people are invested in PG&E. There's a good chance that somebody watching this video is invested in PG&E doesn't even know it. Right? Anybody who's invested in a mutual fund, there's a higher chance that they're invested in a California public utility. Right? And, people don't know what they own. I remember back in 2004, George W. Bush owned a timber company. He had no idea he owned a timber company. That was because his stock portfolio was being managed by somebody else. He had no clue, right? People don't know what they own. So when we say, oh, poor shareholders, we're probably shareholders. There's a decent chance that we have some sort of investment in PG&E. I believe they are a publicly traded company, although if somebody wants to check me on that, they can please go ahead and double check. But the problem here is that people lose, right? PG&E as a company is fine. If they can't pay, they can't pay. They're what's called a judgment-proof defendant, right? And PG&E isn't a person. You know, everybody who works for PG&E, their CEOs, their executives, whatnot, they're going to be fine, right? They have large houses, right? They're not going to lose those large houses. You can't pierce the corporate veil on PG&E, right? You can't get to the personal assets of their owners, right? So they're going to be fine. Like, the people causing the problems with PG&E wouldn't be punished in a bankruptcy proceeding. So even though we'd want to stick it to PG&E, we'd fail miserably. We'd just stick it to ourselves. PG&E would charge us more money. So that's the problem that people faced earlier this year. That's the problem the very democratic government of California faced earlier this year. So the question was posed to me, I mean, why does PG&E have, quote, a liability shield? And here's the thing. First and foremost, it's not technically a liability shield. Everything I explained about inverse condemnation and PG&E's legal responsibilities do not change. As a matter of fact, the law itself has a very specific carve-out that said nothing in this law is meant to alter any legal obligations of any parties. What it does do is, instead of creating a liability shield, it creates essentially a bailout mechanism. So PG&E, if they're ordered to pay damages, can apply to the California Public Utilities Commission to see if the PUC can get their fund, they have like a bailout fund, right? If the PUC would pay them from that fund. And in order to pay them from that fund, PG&E has to show that they were operating reasonably, that they did reasonable, diligent efforts to make things safe, that they were compliant with environmental regulations. There's like an 11-step plan. But you'll notice the big term about there is reasonability, right? So effectively, what it does is it restores PG&E back to that reasonability standard. But it does it in a two-step way. It doesn't do it in the court system, right? PG&E is still liable there, like I just said. But it does allow PG&E to get money from the government to pay that off. And it applies a reasonability standard. It's not automatic, right? PG&E, a lot of people have complaints about PG&E's management of safety and whatnot. The PUC can still deny PG&E funds based off of that. If it turned out that the downed line from PG&E in the campfire was because PG&E knew about it and did nothing, PG&E screwed. Same with any other fire in the future. Although I say the campfire, I retract that, because the law actually didn't cover the fires from 2018 because they hadn't happened yet, and they didn't cover the fires. They covered the fires from 2017 because they had already happened. They covered the fires from 2019 because they were yet to occur, and it left the gray zone, which is of course when the campfire occurred. So the reason this kind of got brought back up quickly was because California had to do a patch quilt and basically say, okay, we're going to bail out PG&E this one time, but that's it. Right. So I say the campfire, but let's say a situation similar to the campfire occurred. PG&E would still have to show they acted reasonably. So in that sense, it's good. PG&E, the other big objection to the bill is that it allows PG&E to raise rates. And it kind of sort of does. Keep in mind what I just said at the very beginning. The PUC was allowing PG&E to raise rates anyway. And they had a formula that basically said, look, PG&E's profit-earnings ratio is a little down, so they got to get more profit. In order to do that, they have to raise rates. What the law says is that PG&E can still do that, but they still have to do that with the old ratio, right? So they can ask us to, quote, bail them out, but the rate increases could only exist if it affected the PE ratio in the way that it had been affecting them in the past. So in other words, in an indirect way, yes, PG&E can ask us, but only in the way they had already been asking us, right? The other argument, and I say this all the time on these videos, of course, is the money doesn't come from trees. I mean, it does, but there's no money tree, right? You have to actually print the money. So the money obviously comes from somewhere, and obviously the Public Utilities Commission is going to get money from the state government. The state government's got to get it from somewhere, and that may, hopefully not, but it may force them to sell bonds. And as anybody watching this channel knows, California bond indebtedness is a really, really bad idea, right? Because it causes things like tax increases on gas and other necessities. So, before we, say things like PG&E bad, and this bill causes rates to increase, yes and no. I mean, it does say that PG&E could increase rates, but it very strictly limits that, and the mechanism is the same mechanism as it was before this bill was passed. Was that mechanism all that protective of consumers? Probably not, right? But that's your real issue, right? The real issue is attacking that mechanism, right? One wherein the PUC allows PG&E to talk about their PE ratio. But when you do that, remember, we're talking about PG&E. We don't want PG&E to go bankrupt, right? We don't want PG&E to basically be able to... PG&E went bankrupt before. They went bankrupt before in 2000, and I think it was 1 or 2, right? And their bankruptcy plan ended in 2012. And it cost families an extra $1,300 to $1,700. It cost per consumer an extra $1,300 to $1,700 in that time. And admittedly, that's over 10 years, right? But still, a little more money in our pockets, the better. So, the long and short of it is this. The reason I call this 1997 decision a bad law is because I think it was a bad law. I think when the California Supreme Court basically says, we don't care if you're a private entity or a public entity, and the California Supreme Court basically says, look, if you get this land that was taken by the government, you're liable even some odd in the future, that's a problem, right? That's a problem because it disincentivizes private companies to actually want to develop on that land. We don't want that. We want private companies to develop, right? We hope, and admittingly, it's stress on the word hope, that the federal government or the state government, usually the state government, condemns land for noble purposes, for truly public purposes, highways, byways, right? And even if they do something as controversial as take land and give it an extra tax base, and that's their sole purpose, we hope that that's at least justified under a good faith basis, right? But if it's not justified under that, well, even if it is, right? If it is justified under that good faith basis, we don't want private companies to be hurt by that scenario. We don't want private companies to be in fear that they are strictly liable for things that are caused by the mere fact that they improved upon that land. That's a very dangerous standard to set. It's one thing to say the government should be strictly liable when it does that. It's another thing to say that even private companies that weren't subject to the original taking or the causers of the original taking, are liable. And that's why it's a bad decision, because it puts private companies at edge. And it operated exactly as it intended. They were liable, routinely, mechanically, almost religiously. Right? And what happened? As a result of that action, as a result of that doctrine that said effectively that private utilities were always going to be liable for pretty much all the land that they had, you caused them to be in a state of near bankruptcy. And we don't want that to happen either. We want people to be held responsible for their negligence. We want people to be held responsible when they have perhaps a deficit of power that benefits them. Right? If somebody has power and somebody uses that power, they're not in an equal relationship with us by the definition of the word power. So we want those people in power to have extra responsibility. I'm going to resist the Uncle Ben quote. I'm going to resist it. I think I am. We want people in power to use that power heavily responsibly. We want to add extra responsibility to them. So I get it. The problem is when you do it with a private company, and that private company has millions upon millions of consumers, you're hurting the consumer in the long run. Not the short run, but the long run. Right? The people who suffered fire damage will eventually get paid out. First by their insurance company. Right? Their insurance companies will eventually get paid out by PG&E. But PG&E needs to be paid out in order for this system to work, because ultimately, what do we want? We want people to actually, be restored from fires. But we also want electricity. We also want reasonably cheap electricity, right? And if we keep pushing PG&E to a brink where they're going to have to charge us more, we don't want that. So this bill was created to stop that. Better to create a government backstop, even if that's imperfect, right? Even if it's imperfect in the long run. Better to create that backstop to save PG&E, to make sure that we don't suffer in the long run. Because PG&E will make us suffer in the long run. Not their owners, not their CEOs, not any of them, but us. Because they can pass the cost on to us. And even the PUC is going to let them pass the cost on to us. That's what they've been doing for the last 5 years. So as unsavory as a PG&E bailout bill is, it's needed. It's absolutely and utterly needed. And the reason it exists is to help PG&E manage the very problematic doctrine of strict liability as it's applied to them. So if anybody has any more questions or any more comments, let me know. Any more topic ideas, PM me. Let me know on Facebook. Let me know on YouTube. Anyway, thank you very much for watching, guys. Have a nice day.